Good morning, colleagues, and a warm welcome. Thank you for joining us in this webinar on the Employment Sexual Harassment Prevention Act 2017-21, where we will be discussing the fundamentals of this legislation. Please note that this presentation is being recorded. I am your moderator, Jeanette King, Human Resource Officer at the Learning and Development Directorate. Our presenter this morning is Mr. Wayne Sobers, whom I will formally introduce to you shortly after I have shared with you the guidelines for your participation in the webinar. So as we go on to the next slide, I will share those guidelines. We would need you to mute your microphone during the presentation and turn your cameras off. Pause or minimize distractions as much as possible. Take some time to reflect on your relevant issues that you may wish to share later. You can share your information, comments, and queries using the chat. There will be a questions and answers segment at the end of the presentation where you're invited to post your questions in the chat, and there will be shared with the presenter who will respond by audio. Ladies and gentlemen, allow me to introduce our presenter, Mr. Wayne Sobers. Mr. Wayne Sobers is the Acting Deputy Chief Labor Officer at the Labor Department, Ministry of Labor, Social Security, and Third Sector. In his role, he assists the Chief Labor Officer in managing the department and also serves as an advisor on labor legislation and industrial relations practice, and as a facilitator in conflict resolution and dispute settlement processes. Mr. Sobers has conducted numerous training sessions on labor legislation and employment relations practice for public and private sector organizations, as well as for shop stewards of the Barbados Workers Union. A member of the Chartered Institute of Personnel Development and the Human Resources Management Association of Barbados. His qualifications include a Master of Science degree in Human Resource Management from the University of Surrey. A warm welcome, Mr. Sobers, and a pleasure to have you present this information in this forum this morning. Ladies and gentlemen, I leave you in the capable hands of Mr. Wayne Sobers. Over to you, Mr. Sobers.
Thank you very much, Mrs. King, and thank you for your warm welcome as well. And I want to start by extending thanks to the Director General of the Ministry of the Public Service for inviting us to share with you this work. Events such as this represent a significant part of our own mandate, as we are required by the Labor Department Act to give technical information and advice wherever it is needed. So we do look forward to sharing with you, and hopefully by the end of today's session, our participants will have a better idea of the responsibilities and the rights afforded by the Employment Sexual Harassment Prevention Act. And of course, whenever we speak of the rights, because the main purpose of the Act is to provide rights for workers, but it also comes with some responsibilities. And we encourage everyone to pay careful attention to those responsibilities, because breaching those responsibilities may also be expensive in more ways than one. So we look at our aim today, which is, like I said at the beginning, to sensitize public officers in relation to this legislation, and also as to how we may promote a culture, that is free of sexual harassment. A few years ago, while addressing the International Labour Conference, the Director General referred to the Me Too movement as just the tip of an iceberg. And he was, expressed the view that the issue of sexual harassment in the workplace was much greater than what had been established and what was shared during the Me Too movement. So in our own area here, in our own jurisdiction, when the act was passed, many persons did indicate that it was rushed. It pretty much was rushed through, but that is so far from the truth, because this matter engaged the attention of the Ministry of Labour as far back as 1998, when a policy paper was prepared for the consideration of the Cabinet, and then subsequently in 2004, when another Cabinet paper was advanced. In between those two dates, the Chief Personnel Officer, by circular in 2003, found it necessary to comment to permanent secretaries and heads of departments that in relation to the number of cases involving allegations of sexual harassment against public officers. So it is not in any way new. It certainly predates the Me Too movement, and we think it is really necessary for workplace health and wellness. So our objectives today, like I said, we discussed some of the key provisions, and we will discuss as well your responsibilities in maintaining a harassment-free workplace. And we will do it through these topics. We do a brief introduction of the main provisions of the legislation. We'll discuss with you some of the things that constitute sexual harassment. And we will spend some time addressing the complaints mechanism and what are some of the penalties for those persons who fail to adhere to the provisions of the legislation. Now, the Act came into force in 2017, December 2017, and I gave you the background in terms of the length of time really that it's been under discussion by the ministry, and the fact that the essence of it is to protect workers as outlined earlier. So what are some of these main provisions of the Act? And you ought to know that we are speaking primarily about the work environment. It is protection for employees, and you certainly cannot depend on it outside of the workplace setting, because if you, as we get closer to the end of the presentation, you'll note that complaints under this Act go to the Employment Rights Tribunal. So it has little bearing outside of the workplace setting. And we mentioned already that it will provide a mechanism for addressing complaints. And then it also addresses the question of what happens when a person is found to have breached the provisions in the legislation. So the question is, what is sexual harassment? And the Act does not provide a nice one-sentence definition, but it really speaks to a number of scenarios which may lend itself and which may be considered to be inappropriate behavior. So just using suggestive words, comments, jokes, gestures, but note, it is not just using those, but that these must be offensive to the other person. and it must annoy or alarm or abuse them. So if the person is not annoyed, then it wouldn't be deemed to be sexual harassment. Obviously, the second one will be more obvious: physical contact that is uninvited, and this can come in many forms. Requests for sexual advances or for sexual favors. These may seem fairly obvious. Then there's the asking a person intrusive questions. These may take this may take many forms. So you may have somebody, as was stated publicly a few years ago in an ad for a series of seminars, somebody asking, you got a man, you got a partner, you got, you know, those types of questions that a person may find offensive. And then there's one that is very prevalent nowadays in this age of social media and so on, the sharing of offensive material, whether it's be by WhatsApp message or email, or even still nowadays in old-fashioned paper communication, telephone calls, and then the final point there is any other sexually suggestive conduct. So it could be maybe a glance, it could be nonverbal as well as verbal, it could involve physical activity or otherwise, but the essence is it's sexual in nature, the conduct is sexual in nature, and it is offensive to the other person. And in addition, we should note that there is also the concept of creating an intimidating workplace. So, and this can take many forms. So just take as an illustration, in my role here as Deputy Chief Labor Officer, I've scheduled some performance appraisal meetings with staff members, and they know it's going to be over the next 2 weeks. In between that, say on Saturday, I go to the beach and I see a young female officer in a bikini for the first time, and I am besotted. And here I am trying to chat with this lady, even though she's saying she has no interest. And I've made several attempts, and she has declined all. And she's a temporary officer, and her performance appraisal is coming up next week. Is it likely when she steps into my office on Wednesday next week that she will be the most comfortable and confident person that she will receive a fair assessment? And an act such as that, even though it didn't occur in the workplace, it could have the effect of creating a difficult environment for that person to working. So then we have to be pay careful attention to this concept of creating a hostile or difficult workplace for other members of staff. In addition, I also would wish to draw your attention to the concept of workplace, because while in the past we tend to view workplace as the brick and mortars place that many of us come to on a daily basis, this goes a little further, and it defines a workplace as a location or place where an employee may attend to conduct the business of the employer. And that also includes things such as attending seminars and conferences and so on, even training, even though it may very well be overseas, could very be out of this jurisdiction, but it could extend there. Imagine that there is a conference, let's say in Miami, and there are 2 persons attending. It is quite possible that one could commit an act of sexual harassment against the other. So the workplace is no longer limited just to our brick and mortar physical space that we drive to on mornings. So again, these things we need to take into consideration. And of course, the legislation makes it very clear and speaks directly to the whole question of quid pro quo sexual harassment, or what many of us may be aware of in Bajan parlance as work for work. I'm sure that many of us have heard that term, but the legislation does frown on this behavior where a supervisor or some person is trying to make somebody feel that in order to continue working or to gain a promotion, that they must consent to sexual harassment. Note that sexual harassment is not limited to one gender or indeed only to employees at the I should say that it is not limited, and that employees at any level within the organization may be a victim of sexual harassment in much the same way as a lower level employee may be. So it is quite possible for a worker, let's say, for want of a better term, a shop floor worker, to sexually harass his head of department, whether that head of department is a male or a female. So it can be really any combination of male and female, employer, manager. When I say employer, I'm speaking to manager, head of department, persons at that level. The legislation actually says employer, but for our purposes, we will adapt also the term of head of department. And note also that a client of the business can also commit sexual harassment. So once the employee is at work, he is protected from both his fellow employees as well as persons who may do business with that organization. So what are some of the responsibilities of our employers, or in our case, our heads of department? First of all, the employee, the employer, the head of department is required he's required to maintain a workplace that is free of sexual harassment. And we note right there every employee, because yes, it is the head of the department with the greater responsibility in terms of formulating policies and investigating claims and so on. But every single employee has that responsibility to maintain a safe workplace. So the employer also has a responsibility to ensure that workers understand, everyone in the business understand the policy statement against sexual harassment. And that term was written in that way, recognizing that it's not just enough to give a person the policy, appoint a person to the policy, recognizing that unfortunately in our business environment, there are some persons who may have a disability or a challenge of some kind. And so it may be necessary to explain it to them. Certainly, if the person is visually impaired, it would do no good to hand the person a sheet of paper and say, here is the policy. You would have to present it in a form that that person can understand the policy as well as their responsibilities and rights under the legislation. As we will see, the employer has a legal obligation to respond very quickly to complaints of sexual harassment, to investigate them, and to decide on the matter one way or the other. The employee is responsible, as we said before, to adhere to the policies and to maintain a workplace that is free of sexual harassment. And we encourage very strongly that where sexual harassment has been committed, that you lodge a formal complaint so that the matter can properly be investigated and dealt with. I've said before about the role of the employee, and remember our role, all of us as employees, it is an implied term of our employment that we will assist in meeting the goals and objectives of the business. If we can't do those, then there's no place really for any one of us. And part of those objectives and goals would be to follow the legislation, and hence we say the employee has a fundamental role to play in in assisting with developing and maintaining a workplace free of harassment. So having encouraged you to file a complaint, having been exposed to sexual harassment, how then do you go about filing this complaint? What is the correct procedure? Whom should it go to? And before I go on to that point, there is another point that I should have made earlier, and I will do so now. That earlier we mentioned these 7 points that the legislation had identified as ones that may result in a claim of sexual harassment. But note that there is a proviso in the legislation which says that the circumstances of the action or whatever it is, it must be one where a reasonable person would consider the conduct to be offensive. Now, how do you define a reasonable person? And it really has to be on the balance of probabilities. And hence the reason why the employer has that obligation to investigate. And as we will see shortly, the worker has the right as well to appeal if the decision does not go against him. So while the legislation is broad in terms of covering these various acts that may constitute sexual harassment, it also mitigates against persons who may be deemed to be hypersensitive. Because we know that there are some persons in all aspects who may be more sensitive than others. So there is that rider there. It must be in a circumstance, these acts, these 6 or 7 points, must be in circumstances where a reasonable person would consider the conduct complained of to be offensive. So having said that, then how do we consider this question of the complaints mechanism? And we say that where you should make your complaint will depend very much on the context, on the circumstances, and on the parties involved. And I should say that in employment relations, we say and we practice and we encourage every case is determined on its own facts. Sometimes the cases may look similar, but the context may be different. And that is why the employer is required to investigate each complaint on its own merit and not based on what necessarily may have happened in the past. So if it is employee on employee conduct, harassment, if the action is employee on employee, but then it should be lodged with the head of the department or his nominee. So in some organizations, and it is unlikely, it probably should not be the person who is at the very head of the organization, except when the complaint is against a senior manager. So it may be reasonable for, in a ministry, let's say, given the typical ministry structure, for complaints to be received by a senior officer, either at the level of SAO or at DPS, which would leave room for an internal review if the employee needed to appeal the decision. If it is against a person at the level though of DPS, then you would expect that it can only go to the PS. All right. So the departments, ministries should have a senior officer though to receive these. This kind of complaint, the complaints under the Sexual Harassment Act, should not necessarily go to anyone other than at a reasonably senior level within the organization. If the complaint is against a client of the organization, then it should be lodged with the head of department, because if it is somebody who's coming in to do work in my department, certainly we would have no jurisdiction to investigate him and apply sanctions. So it really should be made to the organization who employs that client. If it is against the head of department, the permanent secretary, whoever, then it should be lodged directly with the chief labor officer. And similarly, if the head of department is claiming sexual harassment against somebody else in the organization, it can only properly be lodged with the chief labor officer, because there would be no other officer there who can hear a complaint against the person at the very top of the organization. The legislation requires that all complaints should be lodged within 3 months of the occurrence, even though that may be extended in extenuating circumstances. So if, for argument's sake, some person had an experience that was so traumatic that they had to seek other attention and maybe needed a period to recuperate, then 3 months may not be enough. But certainly you wouldn't allow an extension for somebody who says, when you question them, well, I didn't feel like, or I was talking to my attorney and I didn't get a chance, which we hear sometimes, not necessarily under this act, but sometimes when persons applying after the statute of limitations has run out, they say, oh, I was discussing the matter with my attorney and I didn't remember to come to the chief labor officer. In that case, we would not really encourage it, and would probably have the tribunal confirm that line of thinking. But essentially, you should try to get your complaint in for 3 months. So you wouldn't find, as happened with the Me Too movement, where people would come out the woodwork 6 and 7 and 12 years after the occurrence of the event. And and when you say the occurrence of the event, you're speaking really, if it's multiple occurrences, then you would be relating to the last time that the sexual harassment occurred. So what is required of the employer? Oh, and I should say that complaints must be in writing. You wouldn't present a verbal complaint and expect to have it dealt with. The employer should not commence an investigation of sexual harassment based only on a verbal accusation. Once he has received, once the employer has received the complaint, then he has a certain course of action to take. The first thing he's required to do is to inform the accused person in writing. So you see, given the sensitive nature of this topic, of this subject, then the act requires that we have a proper record of what is being done, because it is very easy for somebody to say, I do not recall, or I cannot remember. This happens so often in our law courts. So the employee presents his complaint in writing, and the head of department informs the accused person in writing within 2 working days of receiving the complaint. If it is a client, somebody outside of the organization who is being accused of the sexual harassment activity, then he has to alert that person again immediately, and then he has to commence any investigation within 14 days of having received the complaint. The act doesn't say it must be finished in 14 days, because sometimes it may not be. In this type of instance, there's often questions such as sick leave and so on to consider. And then sometimes you just may need other information, or you may need sometimes to have specialist witnesses or whatever. So it may not be necessary, it may not be possible to finish it, to finishing the investigation within 14 days, but you certainly should make every effort to include it, to start it, sorry, within that time period. Where the head of department is satisfied after the investigation that sexual harassment did in fact take place, then the employer is required to take appropriate action. And let me say that the action should also be consistent with the request of the person who's making the complaint. Some persons make the complaint and all they require is for the behavior to stop. So that may be enough based on what is required by the complainant. And you should know as well that the complainant may request to have the case discontinued. In many ways, just like the court system, but he may have it discontinued at any point, whether it's before the employer, whether it's before the chief labor officer, whether it's before the employment rights tribunal. The complainant has that right to have the investigation stop at any time, but it must be done in writing. He has to make that claim in writing. Where is the situation that the client has been found to have committed an act of sexual harassment, then the employer must do whatever he can to remedy the situation. And this could take many forms. He could have that person not come back to the business. He can, if it's a self-employed person, he can refuse to do business with that person. If it's a company, he can have that person not be reassigned to do business with his organization. But whatever is necessary to bring that situation to an end, the head of department would be required to take that action. And in situations where the investigation has revealed that a sexual harassment did not occur, then that too must be reduced to writing. And not only to writing, but the employer is required to give a reason. So he should justify why he is of the view that sexual harassment has not been committed, and not just say, no, we don't find sexual harassment. You go on to list the reasons why they're of the view. It may very well be that the person was hypersensitive. So how should we create this complaint? And there is no standard form, I should say, there's no standard form in which you create a complaint, but entities are free to assist in that regard. So a head of department may create a form to help those who may not be able to properly express themselves in writing. But in any event, the complaint should be properly addressed. So if it's the head of department who's accused of sexual harassment, you make sure you send it to the chief labor officer. If it is a workmate sitting next to you who's committed the act, like I said, the employer should designate a senior employee to receive those complaints, because the act speaks very strongly on confidentiality, and confidentiality does, the breach of confidentiality does carry a fairly significant penalty. And wherever possible, it should be written in a concise manner. So you don't necessarily need to have 3 or 4 pages. The narrative may very well be saved for the investigation, but it is just to get the facts over about the issue and what the claim is and what the expected remedy should be. It should include details of the time and place wherever possible, and also if there were witnesses to the offensive conduct. And this may be important because imagine, and maybe I'll speak to it a little bit later, but it is quite important that you have precise information as to when the incident occurred. So if, for argument's sake, an incident happened yesterday on the 24th, but you did not remember that Wayne Sobers made an inappropriate advance toward you, and when you finally decided to make that complaint on the 2.5 months later, you are still within the time. But if you write that date and time as the 25th of February at 10:45, then you will lose the case, because all of you here on this call, about 150 of you on this call, know that at that time Wayne Sobers was presenting on sexual harassment. So you have to be clear, and it is in your interest really to make a proper record of the details of the incident. As I said earlier, the context is important, and so you should also be clear about the circumstances, because remember, if the circumstances are not such that a reasonable person would find this thing to be offensive, then the claim may or may not stand. So you need to give information in terms of the circumstances. And also it would help if you could indicate that you had made the person aware that the behavior was unwelcome. And some of the behaviors that are included may involve some subtle actions. And hence the reason why it would assist you greatly if you had made it clear and said, stop. Don't say, I don't like it. Just say stop. As simple and as direct and as effective as possible. And then if you have evidence to support your claim, again, there's no harm in sending it. Maybe photographs the person sent, a WhatsApp message or something that somebody sent to you late in the night. You can make records of those things and send them, attach them to your claim. And then, of course, you should be clear on who the respondent is, because it may not be enough just to describe the person. So wherever possible, you include as much information about the person as you can. As I pointed out earlier, you include the relief that you wish to get, whether it is that you just want the person to stop sending you these messages, or when you pass down the corridor, tell this person I have nothing to say to me, whatever it is. And then we give you the rider at the bottom that you should not include anything that is false or incorrect. Anything that you know any detail that you know to be false or incorrect, because they attract a rather significant penalty under this legislation. So just bear that in mind as you go about the business of lodging a complaint with your employer. Now, in terms, the role of the Chief Labor Officer is to assist wherever possible in matters that cannot be resolved at the workplace level. So if person A has been found guilty before of harassing somebody, and the person continues with the behavior, then the worker instead of may bypass his head of department and go directly to the Chief Labor Officer with the complaint. If the worker is dissatisfied with the decision made by the head of department, that too may he may appeal to the Chief Labor Officer. And of course, we've spoken about sexual harassment involving the head of department. The Chief Labor Officer's role is quite similar to that of the employer. He has to let the respondent know, the accused know, that there is a claim against them at the office of the Chief Labor Officer, and then he has to proceed to inquire into the matter. The main difference is that the Chief Labor Officer has a certain degree of authority. Some may say power, we say authority, in getting information. So he may ask persons, the employer or whoever, to produce documents or whatever. He may withhold them. He may get information and keep it for a period that will allow him to deal with the matter, as long as he gives proper notice to outline what it is that he has taken. He may take possession of the document or whatever, make a copy or maintain it, retain possession of it during the period of the possession. But of course, he has an obligation to keep it in good order. And then the Chief Labor Officer may also use the process of mediation in resolving the matters. And you should note that mediation is slightly different to what we use as a dispute settlement process. In most other instances, under the other pieces of labor legislation, we use conciliation. But in this one, we use mediation, and this allows us to instruct the parties. Under conciliation, we don't do that. The parties come to the agreement themselves with our support and our involvement. But under this act, the Chief Labor Officer may direct the persons, may tell them what to do, make suggestions to resolve the matter. I spoke to this earlier. We may request information, but like all of the other things, he has to put that request in writing. So the act generates, it maintains that that whatever is done is it forms a proper record, so as to properly evaluate what has been done and the steps taken. Right, so this slide demonstrates some of the things that the chief is obligated to do. And you note that the last 2 points there, he directs the head of department to carry out certain action. He may define the action. So the Chief Labor Officer may have given the person, let me step back. The head of department at the workplace level may have decided, you know what, yes, Sobers did commit the sexual harassment, but Sobers is a good fella, so I can just give you a written warning. The chief may now investigate it and realize, no, this is a little bit more serious than that, and at least he should be suspended without pay for at least 1 week, which is a fairly substantial penalty. And he may then direct the head of department of the level of disciplinary action to take in the case. And note that if the employer then does not follow through on the chief's directions, he may then report that employer to the tribunal for the determination of the tribunal. And also he may submit a report. So you might want to find out, well, how has this been resolved? And what have things been like 6 months down the road or 8 months down the road or whatever the case may be. If he dismisses, right, he may dismiss a complaint. As I said earlier, if the worker asks that the complaint be dismissed, but the act gives him a little more authority. If the chief labor officer is of the view that it was a trivial complaint or that it was not brought in good faith, then he could also discontinue the matter. Now, you may want to wonder about these, what is, in particular, what is good faith? Some time ago, I was investigating the matter and the person made all kinds of accusations against the employer. And I asked him, so what are you seeking? What remedy are you seeking? What would you like to see come out of this case? And the person just said, nothing. I just want to get the employer in trouble. You know, and it can sometimes get to that kind of level. That clearly was not in good faith. He just thought that reporting the employer for whatever reason to the Labor Department would be a negative strike against the employer. So he was just making a claim for that purpose. Someone asked in the chat, when would the services of the police force be engaged? And the police has no role under this legislation, but the person would have a right to approach the police whenever they feel like. So if the sexual harassment included physical action, then certainly that goes beyond this act, and the person may file a claim under the Offenses Against the Persons Act, I think it is. But remember that that would have to be, the person would have to determine how they are going to approach the issue that is before them. And as I said earlier, each case will turn on its own facts. So the chief labor officer may discontinue any matter for the reasons outlined previously, but he must give his response in writing, and he must give reasons for his decision. And again, if the complainant is unhappy, he may appeal the decision of the chief labor officer to the Employment Rights Tribunal. Other ways in which a complaint may get to the Employment Rights Tribunal include whether if the harassment is alleged against the chief labor officer. So if the chief labor officer is the one who is being accused, regardless of whether it is by his staff or whether it is by someone somewhere else, that would go directly to the tribunal. And as I just mentioned in the previous point, if the decision was not fair, the person may then approach the tribunal. I mentioned as well earlier that if the person, the respondent, or indeed the employer who's been given a direction by the chief labor officer fails to comply, then that too may be referred to the tribunal. And sometimes, based on our experience, we will have a sense of what may or may not be settled through mediation, because mediation, persons have to be willing to settle, as long as you will know fairly early on whether the matter can be settled at the level of the chief labor officer, or sometimes it may just be something that requires hearing at a different level. One of the big differences between the chief labor officer and the tribunal is that when a matter goes to the tribunal, you're sworn as you would be in court, and then the laws of perjury and so on come into being. So oftentimes persons who would not admit at the level of the chief labor officer, they will admit readily at the level of the tribunal, simply because you don't want to be caught up in perjuring yourselves on any matter. Again, if the matter was against, I would think maybe somebody who's, say for argument's sake, the permanent secretary in the Ministry of Labor, for argument's sake, because the chief labor officer reports to the permanent secretary in the Ministry of Labor. So he really could not hear a matter against his boss. And, there might be other similar kind of situations where he will know that it is best to have this matter heard at the level of the tribunal. But the law does give him that scope that he can make a determination and have the assistance of the tribunal. So I've been talking for a little while now, and I think now would be the time for you to get involved and to let us know, what impact our session so far has had on you by introducing a few questions. I hope you're ready, and I hope that you can, address these and let us see where your thinking is. So we talked a lot. We have a question here for you to answer true or false. And I can see that we also have a poll. The moderator has opened a poll. So question one, what is the main purpose of the Employment Sexual Harassment Prevention Act 2017? Is to provide for the protection of employees against sexual harassment in the workplace. What's your answer there? True, false, in between, maybe so?
Well, I see, Wayne, that the majority of our participants have indicated true. So I will now share the results of the poll. The majority of them have said true.
Hmm. 99. I wonder who was the person who said false. I wonder if that was me. All right, so we can go then to the second question. Right. Again, true or false, the use of sexually suggestive words, comments, jokes, gestures that may seem offensive to an employee is not considered sexual harassment.
Okay, the responses are coming in now, and I am going to share those. Okay, some persons are changing their minds. Okay, so it's looking to me like the majority are saying false. I'm going to share those with you now.
Is it like the questions are easy, or that, well, we'll see. Yes, all of these are may actually, once they offend the person, these may actually be matters that will attract a claim of sexual harassment. So the third question. A complaint of sexual harassment by an employee, an employee against another employee must be lodged with the chief labor officer. True or false?
see the responses coming in, Mr. Silvers. It is looking like the majority of our participants. Okay, wait, some people are changing their mind. Okay, it looks like the majority are saying false. I will end the poll and share those responses with you.
Yeah, that is a complaint of sexual, right? That is false. He really, and this is assuming that that it is not the head of the organization, but another employee at his level. And then yes, he should go to the mechanism within his organization before the matter gets to the chief labor officer. And question number 4, the employer is required to investigate a complaint of sexual harassment within 14 days of the lodging of the complaint.
See some
The
answers
employer is
coming in.
required to commence investigation within 14 days.
Okay.
What says you, true or false?
It is looking, some responses are coming in and it's looking like the majority are perhaps saying true.
Next time you must
Okay.
put a column saying maybe so.
Okay, I'm going to share
That is
those
an option.
results.
Yes, he must commence. Right, and the 5th question, complaints must be lodged within 14 days of the alleged incident. What says you, true or false? Complaints must be lodged within 14 days of the alleged incident.
Okay, some responses are coming in. Okay, it's looking like majority of persons are saying false. Let me share those results with.
Excuse me. That question is not constructed properly.
All right, okay, so there we are. Complaints of sexual harassment in the workplace must be lodged within 14 days of the incident. They may be lodged within 14 days, but they must be lodged within 30. So the statement is not correct. So the statement is false. They could be lodged within 14, but they must be lodged within 30 days. Thank you for participating. And I just took a minute to read one or two of the questions being posed in the chat, and really would like the opportunity to discuss some of those with you. I also hope to get through to the end of the presentation in the allotted time, given that this presentation is usually one that we conduct over 2 hours. Today we've been asked to do it in much less than that. And just let me take one of the questions in the chat, where the question is, what happens if a complainant makes a verbal complaint, but claims that he is fearful of victimization? If they will make a written one, can the matter proceed? And the matter will not proceed. Certainly the chief labor officer will not investigate it, because the act is very clear that the claim must be in writing. All parties who receive a complaint has a strict obligation of confidentiality. So I think that I'm not sure that the person would be on good ground to say that they're afraid of victimization, because there is protection against victimization for making a complaint or for participating in any proceeding to deal with sexual harassment. So this department would not entertain a verbal complaint. And I would suggest to a head of department that they should not investigate a verbal complaint either. As I said at the beginning, it is very easy for somebody to say, a month from now, I do not recall that complaint. I do not recall, or you misunderstood me. That was not what I meant. You misunderstood me. And because of the damage that a claim of sexual harassment can do, we need to make sure that we get that we have an accurate and genuine claim. All right. So there are some consequences attached to breaches, and that question raised two of them. But so let me just speak briefly to those before I go on to the slideshow, because they're all very relevant. So a person who is victimized for making a claim, then the penalty against the person who victimizes that person is $10,000, a fine of $10,000, or imprisonment for 2 years, or both. And for breaching confidentiality, the penalty is the same: 2 years in jail or $10,000. So we feel that those penalties are stringent enough that nobody will want to divulge your details without good cause. So please do put your complaints in writing. I think we touched on these already. Disciplinary action should be taken by head of department if the employee has been found guilty of sexual harassment, and appropriate action against the client. And this is what the person here was speaking to. The act refers to it as publishing any information in relation to it. And publishing is not only for newspapers. If you send it in a WhatsApp message, if you go and tell your neighbor, or you go and tell the person working down the road from you, down the corridor from you, you are publishing details that you ought not to. And I mentioned before what the penalty is in those circumstances. In addition, and I touched earlier on the question of a false complaint. If you are guilty, again, you have a fairly stiff penalty, 2 years in jail or $10,000 as a fine, or both. Now, let me make a distinction between a complaint that was not proved and a false complaint. All right? A person may make a complaint because that is their view, that is how they feel. The complaint is false if the details were known to be true. So somebody accuses Wayne Sobers in a written deposition. Somebody accuses Wayne Sobers of kissing them in the corridor at 11:35 a.m. on the 25th of February. And that is clearly a false accusation. So the person goes to the head of department, and the head of department goes through it, and you are sure of this date and you are sure of the time. The person says, yes, I got witnesses to prove it. But all of you know that that couldn't be possible, because I couldn't be kissing somebody in the corridor while here talking to you. So that is not the same thing as somebody making a genuine complaint, and maybe the determination is that this person was being overly sensitive. Those are two different things. So it is the false complaint that will attract a penalty, and not necessarily one that has not been proved. So we just wanted to make that distinction, because we don't want that persons refuse to come forward. We want persons to come forward so that we may have a workplace that is free of sexual harassment. So I wonder if you would wish to maybe indicate how you think that sexual harassment could impact the workplace. Any suggestions? You may want to indicate them in the chat. I'll wait for just a moment, and I'm sure the producer will read one or two of them for me. Mrs. King?
I am checking the chat. Okay, we have some responses coming in, and we have Natalie saying a hostile environment. We have Ms. Stout saying low productivity. Alicia says loss of productivity as well. It can cause absenteeism, and it can cause discord among the staff. Tension, interrupt the workplace culture.
Yes, I
Agree.
agree.
Disharmony.
I do agree.
And a high turnover and fears.
Yes, it creates intimidation. The case I mentioned to you earlier with the temporary officer whom I was trying to chat up on the beach, that would create a problem in the workplace. Embarrassment, people feel ashamed and don't want to come to work, or they come to work and they do very little. So I do agree with all of those. It does really present a huge problem. And there was a question in the chat. I'm not seeing it now because I've had a few technical problems here on my end, but somebody was asking a question along the lines of how easy is it to recover after sexual harassment has been alleged and investigated in the workplace. And I will tell you that it is a rather difficult thing, especially in a small team. We have a team of technical officers here, about 8 persons, 4 men, 4 women. And just imagine if there is a claim within that that group that requires an investigation. It's likely to split the units down the middle. It has implications for the effectiveness of the group, the effectiveness of the department, and then so many other issues may arise. And that is why at the very beginning of the slideshow, we said prevention is better than cure. It is better for each of us to take seriously and to maintain a workplace that is free of sexual harassment than to then try to address it after, where you then got to bring in counselors and maybe even transfer staff. Because if it is really bad, you may have to separate the persons, either through a suspension while you're doing the investigation, and then if you find that it has indeed occurred, you may have to separate the staff. In a specialized department like ours, if you have 2 officers available to function, that is a huge blow, because it takes quite a bit of time to train up our officers and so on. So yes, that question, I say it's a rather difficult thing to achieve. And so we've come to the end of the program, and I just want us to summarize briefly for you. And I use this quote from an officer at the ILO. And it says, violence and harassment in the workplace can constitute a human rights violation, which impacts negatively on dignity of the person and the health and well-being of everyone at the workplace. That is so. And I also want to remind you that this act that we are speaking of, it provides for all employees the right to be protected from sexual harassment at work. But it also provides for all of us, for each of us, a responsibility not to engage in anything that may lead to a claim of sexual harassment in the workplace. And I also wanted to leave with you the concept of the work environment, and that it requires careful consideration, especially with respect to creating a hostile environment at your workplace. Ladies and gentlemen, allow me to thank you for your attention. This brings us to the end of our presentation. And I do believe that we would now be available to answer your questions if there are any for us. Ms. Moderator.
Okay, thank you, Mr. Silvers. You would have responded to some of the questions before. We have a few more I've seen here in the chat, and I will share them with you. Okay, you would have responded to the question of a transfer. Because Monica was asking if a person can be asked to be transferred to another department, and I think you would have dealt with that. We have a question from Brian McLachlan. What happens if a complainant makes a verbal complaint against a fellow employee or employer, but claims he or she is fearful of victimization if they make a written complaint?
I think I addressed that one.
You did that? Okay.
Yeah, I think I said that the chief labor officer will not investigate a verbal complaint. And we would advise the employer not to as well.
Okay. So I am checking. I am seeing no further questions. We just have a few comments. Oh, we have a question here from Sharon Rose. I'm not certain what Sharon intends, but her question is, what happens when the employees are family members living in the same home? I am not sure.
Can I use my mic?
Okay, you go ahead, Natty, go ahead and explain
Yes,
to us.
that's in relation to what we're discussing. If you have the same, there's the employees are really family members living in the same home, and they report an act of sexual harassment to their employer or their supervisor. What gives the first step? Is it having raised it there? Do they also have, the employer has to respond to it? Or is this a matter where you take the complaint then to the police? What's the steps there? I'm just a little blurred in terms of family relations, sharing the same workplace, and also at the same time they're having issues at that workplace. What would be the directive that would be given to them?
Well, that is one that certainly, you remember I've said all through that each case will have to be determined on its own facts. And that certainly will require some further investigation. So I would want to know, is it a workplace issue, or is it one that occurred away from the workplace? But it certainly has implications for the workplace, whether it's hostile or otherwise. And certainly that may then require, if it's a situation that occurred within the workplace, well, then it is clear that the act can come into play. But if it is one that started, you said they're family members, what if it's one that started outside? I would think that it might be proper to see how best you can separate those, because you wouldn't really have jurisdiction if the issue occurred within the home. Say the employer can't really investigate that.
Exactly. Thank you.
Yeah. So he would have to. He would have to. That's a very complicated matter, because even sometimes, the law courts advise persons to separate. Don't stay in the same home. Find alternative accommodation.
Right.
And go ahead.
Yes, and then I wondered, in terms of, as we speak about employer-employee, are you also considering the self-employed individual in all of this?
Well, when you say the self-employed, he is a manager. He is managing people.
His own business, yes.
Oh. Well, the workers certainly can report him.
Okay. And it's a family business, yes?
Yeah, we receive
Okay.
complaints from those types of businesses. Once the person is an employee, the employee has the rights and protections of every piece of legislation, of labor legislation. The self-employed person who's a manager, who's the owner of the business, he will not be protected in the same way because he's not really an employee. And if you think about it, when he goes to pay his national insurance, he don't pay the employee contribution, the 11 point, whatever it is, 11.25% or whatever it is. He would pay something different, right?
Thank you so much.
Yeah, okay. There's a question here, can there be gang harassment? And I would think yes. It could be if the person's gang up on somebody in the lunchroom or whatever and engaging in inappropriate behavior. So yeah, a group has made a group has committed an action, and I would think that you can also make a claim against the members who were there present.
Okay, thank you, Mr. Silvers. We have another question here. And this will be our last question, participants. We are about to close the session. What if it's a case of two persons who are accustomed to making these jokes or gestures with each other, and then for some reason, one of them makes a complaint? Would this be considered sexual harassment?
Again, it depends on the circumstances. No. And this brings me to something that I neglected to mention during the presentation, that a single event could result in a claim of sexual harassment. And to answer this question, the first part of the question would be yes. Even though two persons may engage in this behavior regularly, it is possible for one party to claim sexual harassment on the other. The thing is that the person, once the person is offended, you see, as long as the two parties are agreeing and accepting it, then it's not harassment. It is only harassment when a person disagrees. Now, in a case like that, where the person's accustomed making these things, then the person should say clearly, look, I don't want that. Don't do that. But these things, and this is the reason why it is important for every person to engage in the appropriate behavior every day. Because this thing about jokes and so on, it is not appropriate. We sometimes accept it, but it is not the appropriate workplace behavior. And it can sometimes result in these types of things. Sometimes it may even go further. And oftentimes we hear about persons before the law courts for hurting or killing a friend. Sometimes they've been drinking together, you know. So I would say in the workplace, every one of us has a responsibility to engage in appropriate behaviors that would not result in a claim. In safety and health here, we talk a lot about risk assessment. And sometimes a risk assessment doesn't always have to be a formal, long drawn up process. Sometimes it could be a quick thought as to how is the best way to behave in here, you know. And I would say once you walk through the workplace door, put on your professional appearance and conduct yourself in a professional way each and every time. And I think if you do that, then situations such as this wouldn't occur. But by the same token, Stout, I apologize for calling you Stout. I don't know who exactly you are. If the two persons were sitting down at the same table making jokes and laughing and carrying on with each other, and then one of them get up out of that conversation and went to the head and made a complaint, I would think that that may be considered to be made in bad faith. if the person did not say, Mr. Sobers, I think you should stop now. Yeah, I hope you understand what I'm saying there. All right.
Okay, thank you, Mr. Sobers. Ladies and gentlemen, that is the end of our Q&A. And I want to thank you for sharing your questions and your comments and queries. I have dropped a link to our participant feedback form in the chat, and you can click on that form and open those questions. Your feedback is very important to us, so please do I encourage you to complete the form and submit it forthwith. I will now take this opportunity to thank Mr. Sobers for that very informational session, very informative. And I am certain that the Employment Sexual Harassment Prevention Act, as I can see from the amount of participants, has been a very interesting new development in the employment rights. Mr. Sobers, you have something? Okay.
Yeah, I just wanted to make a point that it slipped me to make. So my apologies for coming on you. But
No
just to say to the participants that I'd like to encourage each of you to read a copy of the legislation. It's written in very simple language. It's not long. And what we've given you is really an introduction to the Act. And I think you should read it for yourselves, get read the full text. Of course, if you have any questions, you may contact us here at the Labor Department, but it's always best, especially with such a short piece of legislation and with one that can have so many different, I should say, interpretations in some aspects, that you read the full text for yourself. So that's my final contribution, Mrs. King. Thank you.
Thank you, Mr. Sobers. So again, Mr. Sobers, on behalf of the Director General, Ministry of the Public Service, and the Director of the Learning and Development Directorate, thank you for presenting this valuable information. Gratitude is also extended to the Chief Labor Officer, Labor Department, for the continued assistance by the Labor Department in our efforts to disseminate information and educate our public service employees. Thanks are also extended to you colleagues once again for joining and participating in this webinar on the fundamentals of the Employment Sexual Harassment Prevention Act 2017-21. And you can look out for the email blast on our upcoming webinars on innovation and public service innovation. That's a word to those participants whose questions we were not able to answer. I will pass those questions on to Mr. Sobers, and I'm certain that he will oblige to make a response, and we will email that response to you. Again, I want to extend much appreciation to our Senior Human Resource Officers, Ms. Judy Welch and Mr. Michael Clark, who assisted in the background in their roles of co-host and producer, respectively. Colleagues, I wish you all a very safe and productive remainder of the day and a most enjoyable weekend. I would have posted in the chat that the recording will be made available on the Learning and Development Directorate's YouTube channel. And I would have also posted the link to that channel in the chat. So you can scroll up and find the link to the Learning and Development Directorate's YouTube channel. Ladies and gentlemen, again, have a wonderful day and a wonderful weekend. Bye-bye.
Thank you. Thank you.
Thank you, same thing.
Bye.
You and goodbye.